right?
Yeah.
Seattle beat Arizona 23-20 on a last-second field goal to kick off week 4 of the NFL season. The Seahawks are 3-1.
If my wife pops in here, don't panic.
No worries.
She's my ride. But she's at the store.
Okay.
I'll tell her to be quiet.
She,
1951. This is the legend. 105.3, 95.3, WDXE.
and it's Friday, and it's time for Bulletproof Estate Planning with my good friend Stan Pierchoski Estate Law, and he's preparing himself as we speak.
I am. Good morning, Jeff.
It is Friday. We made it all the way around the week.
Yeah, I got my phone to do something weird. I was going to read you a quote.
Oh, okay.
Anyway, yeah, this is Bulletproof Estate Planning.
Yes,
we're
it is.
We're going to start talking about that here real soon. But again, we don't remind people in the beginning because sometimes we forget. This is an interactive show.
Yes.
Call in. You're going to call in. It's the phone number, of course, is 931, of course, 766-9393. Easy number to remember. 766-9393. If you have a question, want to share your experience. How do I get that back to the regular screen? Does that make sense?
I have no idea.
I don't even know how I got there.
I don't know.
This button over here doesn't work right. But I want to, never mind, I got it.
Okay.
You were talking about quotes.
Yes.
Easy quotes.
Easy.
And actually, one was about tasks being easy or something like that.
Yeah, yeah.
When I was out that week and I was in Texas, one of my staff members sent me this quote from somebody named Thomas Schelling. I have no clue who it is, but I think it's a good one about tasks. Talks about the hardest task, okay?
Yeah.
Your task is easy when it's over. The hardest thing is one thing a person cannot do, no matter how rigorous his analysis or heroic his imagination, so no matter how hard you try,
Yeah.
is to draw up a list of things that would never have occurred to him.
Yes. Yes. So draw up a list of things that would have never occurred to you. That's pretty good.
My response was, that's a funny quote.
It is a
I
funny
said,
quote.
It's a funny quote because that list would never have occurred to me.
Yeah.
So anyway.
That's good. I want to remember
It
that.
was. So, hey, listen, we just had a seminar last Saturday, and it was here. It was a great crowd.
Oh, yeah.
You realize, I always say when we have seminars here or at the theater in Pulaski,
Right.
that we have a big venue, we got plenty of room. When we were done on Saturday, I counted something like 6 chairs. The tables were all consumed. We had just chairs in the back. And if I would have rated every little chair in the corners and where they have one over here holding up a monitor,
Yeah.
there were 6 chairs left over.
Oh, wow.
And no tables.
Wow. Good
and
for
you.
you.
And we had something like four or five people that had RSVP'd that couldn't make it.
Yeah.
We had like 12 or 15 walk-ins. So, I mean, I encourage that. But I just
Yeah.
want to make sure. That's kind of why we keep the head count. If I would have had to do something with more chairs, I would have done so ahead of time.
Right,
I
right.
don't even know if you had some anywhere. I doubt it. That's the big room where they keep that stuff. But I would have worked something out if I knew we were over that size. So, anyway, it was a great seminar, great crowd, very
Yeah.
very attentive. You know what I mean? I didn't look like anybody was really bored with me. A lot of good questions at the end. We were there for a while. So a lot of people engaged too. So it's I'm happy that people want to hear what we have to talk about, or at least check it out. You know what I mean? Just hear it, and then just because that's the way that's why I do this. I like to tell you what we can do,
Yeah.
what the options are,
Yeah.
and I want you in that decision-making process. If that's something you think is good for your family, then do it. But if it's not a fit, then we won't do it. You know, there's no pressure. I don't talk anybody in anything. Don't talk them out of anything. Anyway, while I get this out, because I have the address, the next one we do about every other month. So the next one we're doing is November 22nd. That's right before the holidays, right?
That's right.
But this one is up in Franklin. So I forget the county. What is that?
Williamson.
Williamson County. That's right.
Williamson
That's right,
County.
because it's the Williamson County Public Library.
That's Williamson County Public. Is that where you're going to get to it?
And well, we used to do it someplace else, but
Yes.
it became unavailable to us, and it's still unavailable. And I don't know if it ever will be because the owners are doing something with it. But so if you want, it's a little early, but it's not too early to RSVP. We actually already have some, and I've not been there yet, so I don't know the size of it. You know, my marketing team, the girls, go up there and look at it and get it secured in that. But it's going to be the Williamson County Public Library, and the physical address for that is 1314 Columbia Avenue, Franklin, Tennessee, 37064. I'll go over that again at the end of the hour.
I actually have been in that library.
Have you?
It
Okay.
is nice. It is a very nice library.
Good. Actually, some people that came to the seminar, or one person came to the seminar.
Quite large.
GPS did not send them here. they went somewhere else. I forget where he said, but he got in about 15 minutes into the seminar.
That happens.
And he said, GPS sent me to the Country Kitchen. I think they put in Country Cafe or something.
Oh.
Country Kitchen spelled with a K.
Yes.
I think it's looking for a restaurant of types or something.
Yes.
I'm not sure what he put in. He just said it briefly that he was late because
Yeah, just remember WLX, and that's where you come.
and a lot of times I'll say it's the biggest tower in the county. You cannot miss it.
Yeah,
It's like the end of the rainbow. At the bottom, where that thing touches the ground, there's a set of doors there.
That's right.
That's where we are when we're over here.
yep,
So don't try to come in the front doors where the radio station is because it's usually locked if there's anybody here.
Yeah.
There might be somebody here on the weekend, but anyway.
Yeah.
So that and the quote, we're ready to go.
I like the quote. We're going to create a list of things that would never occur to us.
Yeah, which has to, but definition has to be nothing on it.
Nothing on
Has
it,
to be
that's
a blank
right.
list. Because if you
I
put
like
something,
that.
because you put something on the list, it's immediately disqualified as occurring to you.
That's right. And that phone number here again, 766-9393. If you want to talk with Stan during this hour, and we've got him for all the way till 9 o'clock. So very good.
Yeah, I got something to start with. It won't take me too long, but it was an interesting thing that came up this week, and that is, I think I talked last week or the week before about a trust client we had that when we were going to go to put his property in the trust, we found out he'd been divorced for 32 years, but
Yes.
the transfer of property that the MDA said to do
Yes.
hadn't been done. Well, this is something similar. In other words, if somebody doing a trust client, we started looking into the property to put into it. We found a glitch. Okay, but to catch up on the other one, the parties are all in agreement to put it in the trust. I said before it might be an issue,
Right.
but it's not going to be. Everybody's in agreement to do it.
Yeah.
We had a little sit down and talk, and it's really what they all wanted to do in the first place. Somehow it slipped through the cracks, and
Yeah.
as years go by, you're never going to think of it.
Right.
But the parties are friendly, and it's going to work out. But this time we had something unique, and had a piece of property that the trustor, the client, was one of the pieces of property they wanted to put in their trust. And so we were looking, there's 2 or 3, and they were looking, everything was fine. And then my assistant brought to my attention, said, we're going to have an issue with this deed. It says, because this person, it says it's granted to them, and it says like John Doe et al. Sometimes you get a deed, you'll see John Doe, and it'll say edux, E-T-U-X, 2 words. Those are Latin words that mean and wife.
Yes.
Okay. Et vir, V-I-R, is and husband if it's the wife version. But then you don't see that one too often. But another one you see a lot is et al, E-T-A-L, and it means and others. Okay. So there's this difference between a spouse. Et ex and ex vir means spouse, but et al means other people. So basically under the statute it's referred to them as non-spouses. So you got 2 categories, spouse or non-spouse.
Yeah.
And that covers everybody. So she brought to my attention, and here it belonged to the individual who was single, but the other et al were 2 of the children. And the way it surfaced was we were drafting the trust, and we wanted some acreage. We wanted the acreage to go to multiple children in multiple pieces.
Okay.
It was like 100-acre tract or 150-acre tract, and we wanted 30 acres.
So you're actually dividing the land.
Right, 30 acres here, 30 acres there. Took 3 or 4 different children, and in the language in the deed, it was not even an undivided interest to the 3 people. It was right of survivorship. Now, if you remember, we talked a while back that if you are husband and wife, you get entities by the entirety with right of survivorship automatic, whether the deed says it or not. You get it because you're married.
Yeah.
It doesn't hurt for the deed to say it, but it doesn't have to have that. But if you're a non-spouse, let's say you want to own it with your child for some reason, but adult child, and you say we're going to own this together. If you want to own it with right of survivorship like that, you have to say it in the deed. So you have to say, Jeff and was your son's name?
Daniel.
Jeff and Daniel.
Yeah.
Joint tenants in common with right of survivorship. That sort of thing. So if you have the right of survivorship in there, that's what you have. And of course, remember right of survivorship, which is important to this case. Right of survivorship means, say you and Teresa probably own your home that way, right?
Yeah.
So what that means, if something happens to you, and I always pick on the husband first, sorry.
Yeah.
But if something happens to you, all ownership instantly, the moment of death, vests with the survivor.
Yes.
And you can have like 10 people like that, and it's like now you have 9, now you have 8, now you have 7. You know what I mean?
Right.
But you eventually get the last one, and there's no right of survivorship because they're the last one.
Right.
Now, what came up was we wanted to put this piece of property in the trust. And first of all, I brought up to the person, I said, first of all, if we do that, we can, but we need all the owners because you all own this right of survivorship, so you all own it. First, all 3 of them have to put it in. The second problem I have is the other ones have to agree to divide it up more than it actually already is. They're actually giving something up.
Okay.
So, I'd say it's gonna take a deed, depending on how we wanna go, how you wanna end up, it's gonna take a deed to fix it and stuff. So, I mean, kind of not as major as that other problem with it, but it was a hiccup in the deed, cause we couldn't give it all the different people that they wanted to go to unless we had all the owners on the deed's name.
Right.
Or authority. All the owners must be involved anytime there's a transfer of the property, no matter how small. If you have a 1/250th interest in a piece of property, it's gonna be transferred, it requires you, because you have an interest.
Have an interest,
Yep.
an ownership interest in the property. Wow.
So,
It
anyway,
can be complicated.
so well, you know what, it strikes me as this, sometimes folks just don't understand how they own their property.
Right.
You know, when you do a trust plan, we go through that and that stuff surfaces. Might not be a bad idea to look at that anyway. I mean, if you listen to me, you know, here on this show or some of the other ones, I often talk about how you own property in Tennessee. And so,
Yeah.
next time you hear that, jot a few things down and go take a look at your deed. There, you can go get a copy of it at the clerk and master. I mean, the Register of Deeds office anytime. I don't know if they charge for it. They typically don't, but if they do, it's just a quarter a page or something like that.
Yeah.
But and you can look and see what it says. You know, if it confuses you or something, and it's not like you think it should be, give me a call and we'll talk about it.
Yeah.
And I'll tell you what it means. You know. Now, the reason to know that is that what I want?
Yeah.
Because I'm telling you, on both these situations, when I brought it to their attention, they had no clue that was going on.
Yeah.
And I said, well, how did it get this way? And they said, I don't remember. And then, of course, every deed says prepared by, and on both of them, I figured out how it got that way, which I'm not going to say. But,
Yeah.
but the good news is, when we find that, we can fix it. It just takes another deed.
Yeah.
You know.
Yeah, it can be fixed. Yeah,
It can be fixed.
absolutely.
Now, on the inverse of that, let me talk about a common question I get. The inverse of that is, let's say, we'll pick on you again. Now you're gone. I'm going to pick up where you left off.
I have died more times on this program.
Yeah, that's right. But I always bring you back.
You always bring me back, yes.
Jeff and Teresa own it, right of survivorship.
Yes.
You're the first death, all ownership vests with Teresa.
Okay.
Now, suppose Teresa would come to me and say, hey, do I need to change my deed to just show Jeff's name is still on it? Do I need to make the deed show that he just say in me? I said, you know, you kind of could, but I think it would be a waste of effort. There's no need to it. And here's why. If she ever gets around, I mean, right of survivorship has happened already. Ownership
Yes.
is already vested the moment of death. It didn't vest it in a probate court. It didn't vest when a judge said something or signed something. It vests at the moment of death by operation of law. It automatically is hers by the language in the deed.
Right.
So no real need to change it. She's the owner. However, what we do, say somewhere down the road, she wants to put that in a trust or sell it.
Right.
Convey it. When she does that, there'll be a paragraph that say, the derivation clause we call it, this is the same property acquired by Jeff and Teresa, such and such a date on this book and this page deed.
Right.
Say, Jeff having died on such and such a day, allowing Teresa to be sole owner by operation of law. So now the deed owner requires her name to sign to transfer it. You're not yours, even though you're in the title of the deed, but we identify the right of survivorship that has happened, when it happened, and show that she's the only one that has the authority to sign to convey it, because all ownership is now vested with her as the survivor.
Correct.
So some people have insisted that, you know, I know I don't need to, but I want to change the deed to be just me. And you can do that. Sometimes people ask me to write a new deed that doesn't change anything. It's like, that's hard to do. There has to be some kind of ownership interest affected when you do a
Yeah.
deed. Now, that could be something simple as, say you guys own this property and you decide to give one of your in-laws a life estate. Well, it's the same thing. It's Jeff and Teresa to Jeff and Teresa with a life estate for somebody. You know what I mean? So there has been a slight change in the property. You know, you've made a change to it.
Yes.
But if somebody just says, you know, I want it Jeff and Teresa, but I don't want to change any ownership. I want to fix some language or something like that. You don't do a new deed.
Yes.
You can do a correction deed or something called a Scrivener's error, which is, you know, it's kind of like a Rule 60 clerical error thing you can do.
Right.
They call it a deed, but it's really just something changing a mistake.
Right.
A mistake that doesn't affect ownership. A trivial mistake, right? You know.
Yes.
If you look through the meets and bounds and you find out that the surveyor says, you know what, this says 125 feet when it really should have been 225. It was just a mistake. So, you know, it affects the ownership because you're affecting the meets and bounds description.
Correct.
You know, so you do a correction deed.
Yeah.
If you misspell somebody's name, now this happens. you know, no matter how many times you proofread something, I swear to gosh,
Yes.
stuff still gets through. I look at it, I proofread it, I take it from what you wrote when you gave it to me, I let you look at it, you read it, and nobody sees a misspelled name.
Yeah.
And somewhere down the road, I say, hey, such and such is spelled with 2 L's, not 1. And they want it changed. And it's okay,
Yeah.
we'll do a scrivener's error that simply says, because it's a meaningless, it's a non-intent change. Nothing, no intent of ownership or anything is changing. It's like kind of an identity thing.
Yeah.
And we still haven't, the identity still is not in jeopardy because we usually have the person's first, middle, and last name.
Yeah.
So to really don't affect the identity, you gotta botch the name up so bad to the point where we don't know who we're talking about.
Right.
But if you're just going to change that, it's a scrivener's error, so it's kind of like just a clerical error. We fat fingered it and put in an extra L, something like that.
Right.
So it's no, those are they call those, well, they call the correction deed a deed, but it really is just that. It's a document that corrects the deed.
Correct. That is
So,
correct.
That is correct. So that's stuff.
It's just good information though, because a lot of people, I mean, most people don't ever deal with this much. I mean, it's very rarely that they do. In fact, I was talking to someone just this past week. They were dealing with some property, and there was a note on the property, but it was a privately held note, and we're trying to discover whether or not it's been recorded or whether or not it's been paid off. We don't know.
It's private.
So we're trying to figure it out as we speak, and like, okay, we got to figure out if there really is money owed on this property or not.
Was it part of the deed?
No, not.
Just
It should be a deed. It should be a deed of trust and note.
With the bank, it's a deed of trust. I've seen them private where they don't call them a deed of trust. Deed of trust is kind of more of a specific note.
Right.
But you can have just a handwritten note.
Yeah.
You know, you're right. And you have to get a hold of parties to find out if it's been done or not.
Yep. And of course, hopefully, it's been recorded one way or the
Now,
other.
any note you do, deed of trust does this, but if you did a self-financing, they call it, I'm gonna finance it myself.
Yep.
You have to do like a deed of trust does. When the note has been satisfied, it's complete, you file what is called a release.
A release.
Release is very, you know, even the most sophisticated releases is just about a couple sentences long. It says, basically it says, the note of such and such a date has been satisfied. We no longer have a claim on the property.
Right.
And that, or a lien. We never have any, because if you don't pay the note, their remedy is to
Right.
foreclose.
Right.
Their right of foreclosure. And now so they're saying that's over with. We no longer have the right of foreclosure. We had a deal. I was supposed to get the money. When I get the money, you get full ownership of the house.
Right.
That's been complete. And they file the release. So when somebody's doing a chain of title research and they find a note, they're looking for the release. Because if not, the property you, Jeff Hood Realty, is trying to sell is encumbered. And
That's right.
The new owner needs to know that. And the warranty deed is supposed to point all that out. Or the title insurance company will point that out and say, you know, we'll insure this title, but we're gonna carve out an exception for this note that's due, or something like, you know, however they do that.
Yeah.
So, but if you're doing a private note, you should still do the private release. And sometimes if we find exactly the situation you have, and we get a hold of the parties, and it has been paid, oh yeah, it was paid off 10 years ago. I say, okay, let me draft up a quickie release for you to sign, and you say, yeah, I'll do that. And so we make one, and we go and record it to make sure that's been done, so.
Yep.
But you know, it brings up an interesting, I mean, were you done with that?
No.
That was your example.
Yeah. Well, I'm just in this particular case, you know, we've got some parties at this point that don't know for sure if the note has been satisfied or if it's been released. So we're gonna have to do a little research.
You do, and I think I've told this before, but I'm gonna tell it again because one of my star stories about this topic.
Yes.
I was doing some trust work, and I don't usually get involved in divorce work, but the divorce was entwined with this trust. Okay.
Yes.
And so we were trying to divide property. Mom left property to some of the kids.
Yeah.
And one of the kids was married and the wife was involved. Anyway, it was like that. And so we were doing the divorce. But part of the divorce, we were trying to, you know, you talk about the separation of property.
Mm-hmm.
Before we separate property, we've got to identify all that Mom had. Now, this trust is not one that I had drafted, but one of the family members hired me to do their trust. And so when we got to this point, they asked if I could help deal with Mom's, and it kind of got in deeper than I wanted to go. But once you're in, you're in. You know, it's easier to continue on than to.
Yes.
So, and I remember we had my law firm on one side and the law firm over here in Lawrenceburg on the other side. Both very capable law firms, both very familiar with real estate and stuff like that, and all the stuff that goes along with it. And I sat down and I went over, and my assistant, Alex, helps me a lot with the deeds, and We're going over it, and there was like 4 acres we couldn't account for. It just wasn't there. She said, I looked, I called Ed over, the guy at the tax office there, and they can't find it, we can't find it. And so the other law firm said, I got a paralegal that's been doing this for 30 years.
Yeah.
Let her take a crack at it. She couldn't find it.
Yeah.
And so I'm bringing, and I brought it up to the client before, but I never really got an answer that I remember, or I would have said, okay. So one day I brought it up, and apparently he heard me this time, because mom was very advanced in years, and the children were, in their 80s.
Yeah. Oh my.
And so I brought it up one time, and I said, we just don't know. We don't know if it's a, when you calculate old deeds, they use things in, it seems like poles and links and all these measurements we don't use anymore, and they don't account for going up a hill or down a hill, which an aerial view makes it look smaller than it actually is.
Yep.
And they go to an old rock or to a 10-inch gum tree or something.
Sure.
And those landmarks usually aren't there anymore.
Right.
And so you can account for differences in acreage that way. If you do a deed later on, and difference in acreage is never a problem. That's why they use the language more or less, 100 acres more or less. And it doesn't matter what that clause says. I would contend we shouldn't put it in there at all, because what matters is before that is this meets and bounds description. And that's the footprint of what you own on planet Earth, whatever that works out to be. So many people have come to me and said, hey, this deed says I've got 100 acres more or less, but this latest deed that they draft up says I have 95.7 acres. They shorted me 4.3 acres.
Right.
I said, they didn't short you anything. It's a more accurate description. The same lines are there. So they just take a box.
Right.
The area of that box is what you own on planet Earth, right?
That's right.
If it's measured this way and comes up with 10 acres, and you measure it this way and comes up with 9 acres, you didn't lose an acre. You only ever had whatever that box defines, whatever that is.
Right.
So that gets people excited, but that's not the determination.
Well,
of what
we
you
just
own.
have a lot more sophisticated measuring tools now than they did then.
I mean, they do it to 2 decimal points of a foot.
Yeah.
Which means if you walk to the end of the hall, it would change. If you had a GPS thing on your thing and you walked to the end of the hall, it would change.
Right.
But anyway, where was I going with that? Oh, I was just going to say I had a case that reminded me of, what were we just talking about before that? I knew when I said...
Oh, you're trying to find this 4 acres.
That's right, the 4 acres.
You're trying to find the 4 acres.
And finally I sat down, we just have to chalk it up to the measuring of the stuff. He says to me, what 4 acres are you talking about? I said, well, I brought it to your attention a couple of times. He goes, well, do you have a map? I said, yeah. So pull out the map, you get off the Register of Deeds office, you can go, you can get the drawing, or you can get the Google one, that sort of. Well, you pull the one up, show the drawing, he's looking at it. He goes, oh, I remember that. I'm thinking, I'm half elated, we found 4 acres, but I'm half ready to reach across the table and strangle the guy.
We've been looking for this.
I mean, a long time, several parties.
Yeah.
I mean, we racked up a lot of your bill looking for this.
Yeah.
Now, anyway, he says, I remember that. I remember it. A long time ago, I said, Daddy, he traded that 4 acres for a bull.
Yeah, yeah.
I told that story before, didn't I?
Yeah, yeah.
And it's like, I mean, I guess that's an okay way to do stuff. You just need to think of it in terms, I mean, I don't have any problem with trading it for a bull, but it just seems, public record and land ownership needs to be documented somehow.
Yes.
Anything would have helped, didn't it? It would, I mean, my imagination, and this is probably the way it was done. I'm not faulting the way it was done.
Yeah.
Probably said, okay, here, somehow they defined the 4 acres, because that's what they traded.
Right.
Here, from the fence to the creek here, now that's yours, here's your bull.
Right.
And that was the end of the transaction. Now, there's nothing wrong with that transaction. The only thing that, I wouldn't even call wrong with it, the only thing that it causes a problem is later downstream, later in time, there's nothing to designate that.
Right.
And you don't even have to record deeds. It's a good idea too, but there's no law that says you have to do it. So sometimes we run into that, and it can get fun, it can get challenging, it can get pretty bizarre at times. But
if you don't record that deed and you happen to lose the deed that you have, you could be in a mess.
Yeah. Oh, if you don't record the deed, think of it this way: that deed you have, that original piece of paper that's signed by the grantor, the seller, right? That is the only indicia of ownership that you have. And like you said, if that gets lost, you can't. I mean, you might be able to by getting all the parties, but it'd be a tough road to hoe to prove you own that.
That's right.
So that's how the recordation of deeds began. It was that sort of stuff would happen or get stolen, and destroyed by somebody else.
Right.
And then so stuff like that. And we were talking about the acreage being a little more or less. There's a thing, you know, most people here, I've got one in my property, is you have a creek, you know, Big Long Creek.
Right.
And mine's not a small one, but it's not a big one, but it's
Yeah.
you know, active flowing creek. And creeks turn, right? And
They do.
That's what they do. They don't go straight. If they go straight, they'd be going so fast, they'd knock you down at the end, at the other end of the field, right?
Right.
But I'm just saying, they go back and forth. Well, when they do that, a lot of boundary lines go from the middle of a creek. They
Correct.
certainly use rivers for that, you know what I mean?
Absolutely.
That's the boundary line. They go from the middle of it. And so, over time, that changes. They have a name for that. I know one is called accretion, is where you gain property. And I think
Right.
accretion and decretion, I have to look it up, is because being which side of the curve you're on, you're going to gain land or lose land.
Yeah, you can. You
You
sure
know,
can.
so
We run into that
that's
a
what-
lot.
And somebody may resurvey it and be you know, I can't imagine being a lot of land, but
Yeah.
you can run into a survey that's done years and years later, and there will have been some change.
Yeah, in fact, we just ran into that recently on a piece of property where we surveyed and the creek was supposed to be the boundary, but the creek had moved quite a bit since the earlier survey. So there was, you know, some back and forth with landowners. Okay, where is the line really? And there you go.
And that changes with older creeks than newer creeks.
Yeah.
Because older creeks are in like a floodplain, soft, you know,
Right.
and their direction can change within that floodplain easily. Where brand new creeks, you have these big hills on the side of them. You know, I know because on mine, I gotta walk in it with the weed eater when I'm weeding the banks. You know, so that changes slower because it's got
Right.
a lot of stuff to move. But it's interesting, you know. It surfaces from time to time.
It does. It serves a lot.
So anyway,
The survey world. My goodness.
so you know, land is a pretty big issue when we're doing estate planning because that's when you think about it, most people, the average person, at some point in their life, buy property,
Yeah.
own it, or properties,
Right.
and a lot of times, at least for in the bell curve, kind of like the average person, that's usually the lion's share of their estate, and it is so because land is usually worth hundreds of thousands of dollars, you know, several $100,000.
Right.
Nowadays, $100,000 piece of land is on the low, you know, what seemed to be a pretty expensive piece of property is now on the low end of the scale, and it's really not uncommon to see, you know, $400,000 and $500,000 pieces of or primary residence pieces of property. these days.
Absolutely.
And so it's a big chunk of your estate usually,
Usually is.
and so it's a big deal when we do estate planning because we want to pass that to the children, and if we don't want that to get hung up in any kind of probate process, or we want to protect it as an asset so it's not subject to the high cost of long-term care, we move it into a particular trust that satisfies with the purpose, solves the problem we're trying to solve.
Absolutely.
And so we you know, it takes a transfer of that. So real estate comes into play a lot with what we do. So
Stan Pierchoski, everybody, here with Bulletproof Estate Planning, Pierchoski Estate Law, located in Pulaski, Tennessee. The phone number here, if you want to talk with Stan, 766-9393, and we may be about to get one here.
There you go.
We got one of our regulars that seems
I
to
was just
always.
wondering what topic I would talk about.
Yeah.
No, I'll have one.
Good morning. How are you?
Oh, fine. I have a question. He may want to cover this another day, but I'm still a little bit confused about the qualified income trust as to whether it still goes in with the regular trust if you're just doing, you know, he talks about the ones that's just property. And one of the questions I have, and the reason I want to know is I think what happens in a lot of families is one child wants to do this and the other one doesn't. Let's say they're in their 40s or 50s and one says, I don't want my life complicated, I don't want anything. But does Social Security count? And if so, how do you hold that individual? Like somebody says, I'm not going to deal with that. I know you can do or not do Social Security. And I just wanted to cover things like that, like how would somebody talk to a sibling that doesn't want to do this and making it as simple as possible?
Let me ask a question, something that I want you to clear up. When you say a child wants to do something with Social Security, can you define that, what something it means with Social Security?
Just a minute, I can't hear, I'm going to have to turn my
Oh.
radio.
He wants to know, what do you mean by do something with Social Security?
Well, I have read that Social Security, you know, you'll hear people saying, well, I may not qualify because I make more than that in Social Security, $2,000. I looked it up, and it said Social Security was counted as income, but they know, and so I just don't think that was clear either.
Okay.
Got it.
All right. You got it? All right. Well, he'll answer you off there, okay?
Okay.
or on the air, I should say.
I asked that question on the microphone, and I guess it needs to be asked into the phone.
Well, yeah,
I'm far enough away from the phone, I'm sure she didn't hear me, but.
Right.
First of all, she's right, Social Security is income.
Yes.
Now, people, she's sort of talking about getting eligible for care.
Right, qualified income.
And eligibility, there's two financial categories you gotta become eligible in. One is income, and the other one is resources. People often confuse the two, but they're not one and the same. Income is just like Social Security. You don't own your Social Security until you get the check every month, right? And then you own that little bit of it. You get another one, right? It's a stream of income. You can't just say, you know what, I'm probably supposed to live for another 3 or 4 years. I just want to cash out the Social Security that's coming my way.
Right.
You own, it's a stream of income. You don't own it until it becomes income, right?
Right.
Now, that is income, and there is an income qualification in Tennessee for long-term care, and we are what we call an income cap state.
Okay.
Now, I promise I'm getting to the answer with the QIT. You have to understand this to understand the QIT. So you get our cap. If you have $2,901, now that's the number for 2025. It typically changes every January. It goes up, what they say COB, cost of living rise or whatever. So it's $2,901. Theoretically, under TennCare law, if you make $2,902, meaning $1 over, you are disqualified from getting care. I'm starting from the fundamental rules, right?
Okay.
Now, that does not mean we can't get you qualified, because the state has allowed, and this is all states, and they call it, the QIT stands for Qualified Income Trust, and sometimes you'll see it called a Miller Trust. And the reason it's called a Miller Trust is because it came from court law, where it went to court, and the style of the case was either Miller versus somebody or somebody versus Miller. Usually the person that's versing is the head of TennCare, right, the commissioner of TennCare. But whichever way, they call it a Miller Trust, because that's the case that decided this law that I'm about to say to you. And it's okay to be over the income cap if you take everything over the income cap. So, like, let's say you make $3,000 of Social Security.
Okay.
You're $99 too much, right? Because it's $29.01. Let's just call it $100 too much. So we can keep you from being disqualified for TennCare if we open up a qualified income trust. Now, this has nothing to do with the other trusts I talked about. It's a standalone trust. I mean, it's like a 3 or 4 page document. It's a trust you open up with the bank.
Okay.
And you open up it's a trust. You open up a bank account in the name of this trust, which is the trustee is usually maybe somebody else, right? That's child or the other spouse. And what you do is you say, okay, with the let me back up to one more step. When you deal with income in long-term care, all of your income goes to the cost of care. Now I'm talking about the individual income. So we're putting the husband in the nursing home. All the husband's income, fundamental rules, all the husband's income goes to the cost of care.
Okay.
Now, in reality, you can deduct what you pay your Medicare with, and take out that $70 a month personal needs allowance. But in general rule, all your income goes to cost of care. Now, if your income is $3,000, you've got $99 too much. So is that, okay, are we just SOL? Do we not get care because we're
Right.
The answer is no. What we can do, that's why I say income's easy to fix no matter what you get, with one exception. I'll try to remember that when I get to the end of this.
Okay.
We can make you qualified. So what we do is we take the $29.01 that you get. Okay, you get a check for $3,000, right? You take $2,901 of that and you pay that to the facility. Remember, it all goes to cost of care.
Right.
You got $99 too much, right? You have to put that into this qualified income trust. Now, this qualified income trust says, once you put something into this trust, money, because it's a bank account, it's all earmarked for the cost of care. So, and that, if you're starting to think, this is kind of silly, well, you're thinking right, because it is, but this is the way it works.
Yeah.
We have brought this argument till we're blue in the face, and they just won't change it. But, so, what we do is every month, the Social Security account comes in, every month we bifurcate it, we put $2,901 and write a check to the facility, we put the other $99 in the QIT account, then the QIT account, the trustee of that, writes a check to the facility. So all of it went to the facility, but in order to, they don't want to change the rules on the income cap. In order to satisfy the income cap, that preserves the income cap, and it preserves it because the general rules, everything goes, all income goes to the cost of care. Once it goes in the QIT, there's no discretion where it's going to go, it can only go to care.
Yes.
And so they get it all anyway. So years ago, we would say, okay, why don't we just take the $3,000 check and give it to the facility? That's where it ends up, right?
Right.
Why complicate it with half goes here and a portion goes here and the 2 checks go out every month, and they won't give us any relief on that. And I understand their argument. It's like, it keeps things cleaner with the law, but we're still doing the same thing that the law says if we do it the other way. So that's the way we do it, and that's why the QIT exists, and that's how it works. And that's what that court case said. That will be sufficient to not be over-resourced by the income that's more than the cap if it goes into an instrument where it ends up with the facility anyway, because the underlying spirit of the law was that all your income goes to the cost of care.
Right.
That make sense?
Yes.
Does it? I mean, if it doesn't, call back and ask. Yeah.
It's a lot to keep up with,
Yeah.
and I think, you know, for us, we've gone through that, so.
I think the takeaway, without getting into the weeds too much, takeaway is the income cap is, if you're over it, don't panic. That's the easy thing to solve. There's only one time we can't fix it, and I'm talking about that now. I wanted to get sure the first part was done. So
Yeah.
if someone says the cap's $2,900 a month, and you say, well, shoot, I'm screwed, I get $3,500 a month. Well,
Right.
you're not. You're
Yeah.
not. There's a way to fix it. And we do it all the time. It's very common. If you walk into any bank and say, hey, do you do QITs here? They'll know exactly what you're talking about.
Yes.
If they don't, say, do you do Miller Trust here? They'll know what you're talking about.
Yeah.
Because banks deal with them often. But there's only one exception, and that is because, and this, I'm going to go through this mathematically because it makes better sense. It's not
Okay.
heavy math, but if the fundamental concept is all your income goes to the cost of care, okay, right?
Yes.
So let's pick a cost of care, $10,000 a month, nice easy number.
All right.
I don't want to overwhelm you with math, but that is the average, okay?
Yeah.
$10,000 easy, 10,000 no cents. So the cost of care, if all your income goes to the cost of care, we reach a decision point when your income exceeds the cost of care. Now, not many people are in this boat, but let's just say your income was $11,000 a month.
Okay.
And, I mean, you had a Social Security, you had a pension, you had a 401k paying you, who knows, you had
Yeah.
something.
Yeah.
And it was $11,000 a month, and the cost of care at that time was $10,000 a month.
Right.
Would it make sense to you, and you want to get qualified for care, would it make sense to you, send $10,000 to the nursing home, put the other $1,000 in a QIT, and send that to them?
That's the way it should make sense.
But you're paying them $11,000 when the cost was only 10.
That's true.
Because everything in that QIT has to go to the cost of care.
Uh-huh.
So the theory is if you make more than, if your income is higher than the cost of care, you just simply private pay with your income. It's the same result. And you're getting to keep $1,000 now. Because you're never applying for care, so this cap doesn't matter. Remember, the $2,901 cap only applies when you apply, only is of concern is when you apply for TennCare to
Yeah.
satisfy the income eligibility. That's the only time it comes up. So if you make more than the cost of care, you're never asking TennCare to pay it, because they won't. Because they're the payer of last resort. So you get all the income. If there's anything left over, now TennCare steps in to pick up the tab. But if all your income goes to cost of care, it doesn't matter if you make $11,000 of income or $20,000 income. You have enough to pay your own care from the income.
Okay.
So, and that's definitely rare that somebody has that kind of income in the average place. I mean, there's people in that boat. You know, if you're extremely wealthy and you have enough income, you can go to the nicest places you go and pay what they pay.
Okay, so
what they got.
if I'm in my head, I'm playing this scenario out, and let's say that, okay, I do have $11,000 a month in income, but I want to go ahead and set up this trust anyway.
Okay.
Does it not accumulate?
It would.
It would accumulate because it doesn't. It doesn't automatically have to go to them, does it? If their bill is paid, but the $10,000.
No, that's the problem.
It does go.
The QIT, the terms of it's a very specific trust. It
Okay.
serves one purpose. You put money in it, and the money in there can only go to the cost of your care.
Okay.
So if you're not-
so that makes sense.
So
then.
it would accumulate, but it cannot come back to you. It's an irrevocable trust, and
So it can't come back to you.
the trustor, the person has to make it. It can never come back.
So then you would actually just not ever. You
It'd
would
go,
not.
what would happen in reality would go to them, and they would, they're overpaid, so they'd have to cut a check back to you. That's a real problem if you are trying to become eligible, because now you've got this money coming back that we're trying to get rid of.
Yeah.
So I hope it's not clear as mud.
Well, no, I got it now. But in that scenario, you actually wouldn't apply for TennCare.
No, you wouldn't apply. You wouldn't have the QIT. You just take the extra $1,000 and spend it on.
You're
it.
just
You do what you do.
You're just private paying. That's it.
You're private paying because you can do it all out of your income.
Yeah.
Most people, let's say, have $2,000 worth of income. I'm just picking a number.
Yeah.
And it's $10,000 a month.
Yeah.
So all the income goes cost of care, well, you're short $8,000.
Yeah, right.
So that's when 10 cares, they say, we're the payer of last resort, so if you're getting that money, you know, then that goes there first, and then whatever's left over, then we'll pay the difference.
Yeah,
And again, now if you use that, just use that philosophy out and think it through. If I make
Right.
3,000, 4,000, if I make the cost of care an income, there's no reason for 10 care to get involved, and they won't.
okay, all right.
No reason to make the QIT. I mean, you could do it. Somebody would have to come and talk some sense into you, unless there was some reason you were doing that. You wanted to donate.
So there's I may be getting two different trusts confused.
Okay.
Because
talk about it.
you got the qualified income trust, which we just talked about.
Called a QIT or a Miller trust.
And then what about the one that we set up, if, let's say we have some cash, but we want to put this in and we did this.
Asset protection.
Asset protection
The
trust.
income only asset protection trust. They are two different.
They're two different things. Yeah,
That is a trust. It kind of works the exact opposite. You know, the income trust says all your income in this trust, anything you put in this trust, which is overage income,
right,
the qualified income. It's qualified because it's the money that disqualifies you over the cap,
okay.
right? It's
Right.
the extra over the cap that goes in there. That's the qualified income we're talking about. Now, the other trust is an asset protection trust. It's not, you don't put income into that because
Right.
you only put stuff into an asset protection trust. You only put assets in. Those are things you
Right,
own. You
right.
know, when you own a stream of income, you don't really own anything until it gets there.
Right.
And then maybe if you get it and keep it and save it, then you own money in a bank account, but it changes
Right.
all the time. But an asset's like, let's say you have $100,000 in an investment, Raymond James, Edward Jones,
Right.
Morgan Stanley account, something like that. That's ownership. You own $100,000, right? You could put that into an asset protection trust. Now what you're doing is ensuring it does not go to the cost of care. Because remember, now we're putting it into an asset protection trust where you, the person to put it in, the truster of the trust, has no access to the principal. Now that sounds bad, but when I talk about this trust, there's still a way for you to get at it. It's just not access, it's the exercise of a right, but
Right.
you have no access to it. So it kind of works like this. If you have $100,000 in a bank account and you're in a facility and they say, well, you can pay us out of that bank account.
Right.
The answer is, I couldn't pay if I wanted to. I don't, the
Right.
trustor, I have no access, there's no access to it.
Right.
And the reason, and now we're getting into terminology. So when people look onto the internet or they look up, they'll talk about countable assets.
Yes.
And sometimes a lot of people have trouble understanding what a countable asset is. So I always suggest this. Insert for the word countable, available for the cost of care asset. You know, a countable asset is an account that's available for the cost of care. So
Yes.
if you have $100,000 in the bank and you have to pay a bill at the nursing home or wherever you are, or any bill for that matter, you can go to the bank, take some money out to pay it, right? That
Right.
makes it available to you. That makes it
Right.
countable because you can get it. It's yours and you can get it. When we put it in an asset protection trust, we're giving up some of the ownership and taking away our access to the principal. So if we want to pay a bill with that account after it's been put in there, the trust gives us no authority to take it out.
Yeah.
That even prohibits the trustee to take it out and give it to you.
Right.
Now, it doesn't mean you can't get at it. Now, get at is not really a legal term, but access is.
Yes.
Access simply means it cannot come directly out of the trust to the maker of the trust.
Okay.
Remember we talked, that was the one that had that back door where you can distribute it to maybe an adult child who can turn
Yeah.
around and use it on your behalf. That is exercising a right you have. It's not access, because access is a legal term of it coming directly from the
Right.
trust to you.
Right.
So does the opposite. One way it guarantees whatever goes in that trust goes to the cost of care.
Yeah.
And it satisfies the problem of being over income.
Yeah.
This one protects property so it never has to go to the cost of care because of the way the trust is structured. It's kind of, you know, you don't have the ability to,
Yeah.
it's not available to you anymore for the
okay.
cost of care.
Okay. Very good.
Now, that gets, I haven't got very deep into the second trust on that little colloquy right there, but there's a lot more to that. We've talked about it a couple of times on the show where we did a deep dive into the asset protection trust.
Yeah, absolutely.
And that's what I talk about at the seminars, especially the one we call Wills Trust in the Nursing Home. We talk about the asset protection trust because here's another way to think about it. Accountable assets is where you can't have very many of them.
Right.
$2,000. And so many people hone in on the $2,000 and think, well, that's $2,000 to your name. It doesn't mean that. It means what it says. You have to have less than $2,000 of countable assets.
Right.
Countable is a category. So here's an easy way to think about it. When you make an asset protection trust and you move something into it, like take your home. Your home is a countable asset. So is all the other real estate you own. When you deed it to the trust, like we do, the moment you deed it to the trust and sign that document, you have changed it from a countable asset to a non-countable asset. Right. Now when they want to figure out, let's say you put a $500,000 home into this trust, and if the $500,000 home is a countable asset, how much do we have too much?
Right.
We're $498,000 over resourced if we're only allowed to have $2,000 of countable assets, and the home's a countable asset, right?
Right.
Now, I'm not gonna cloud the situation with the fact that it's an excluded asset. That doesn't change it from being counted, it just does something. But we'll just say real estate.
Yeah.
$500,000 real estate, if that's not an asset protection trust, we are $498,000 over resourced, and if it's a countable asset, that you will never be eligible for 10 care, because they will expect you to sell that property and use that to pay your care, because they are the payer of last resort. This is an available asset to you. That's
Wow.
gotta be gone first. So, the moment you put this into the trust, you've changed its posture from a countable asset to a non-countable asset. Why?
Yeah.
Because now you have no access to principal. You can't get at it.
Right.
And the thing I tell people to memorize at my seminar, there's two concepts. One is, if you can get access, remember access is a legal word.
Right.
If you can get access to an asset, so too can your creditors.
Right.
And the creditors I'm talking about are future creditors. People always say, well, I don't owe anybody anything. That's great. I'm talking about future creditors that don't exist yet. You can't defeat an existing creditor.
Right.
That doesn't work.
Right.
But one of the biggest creditors you're ever going to have, if it comes into your life, is long-term care. And
Right.
that's what I'm talking about. Now, when they say, okay, what countable assets do you have to pay us with? Or what countable assets you have as we're looking at whether you're eligible or not?
Right.
Well, $500,000 of countable assets has just been removed from that equation.
Right.
So you can put that $100,000 bank account in there too, right? You can put lots of different property. You can put any kind of property in these trusts, and when you do it, it goes from countable to non-countable. Now, we're selective in what we do. We don't put everything in there. We're selective by choosing things that I said there's a way to get at the property. It's kind of an indirect way, but it's but you can do it. But we like to put things in there with a little bit of thought process, things we don't plan on really getting into to live on.
Right,
If
right.
we do that, then we never have to do anything. But it's
Right.
always good to know that if circumstances change and now you may need that asset, there is a way to get to it. And you're getting to it is not access. So when I say no access to principal, people think, well, it's gone, I'll never see it again, I can't use it, it's just lost forever.
Right.
Not so. It's in your trust for your benefit. We can get at it, which is not access, because remember, access is coming right out of the trust to you.
That's right.
We can get at it and get the use of it or get the benefit of it. We just have to do that a certain way, which is not as easy as going to the bank and say, hey, give me some money out of my bank account.
Yeah.
But it's not much harder than that, but you can still do it. So I say, why do it any more than we have to? So let's just put stuff in there we're not thinking we're gonna need to live off of. And then
Right.
we may never have to do that.
Right.
And that's the theory behind it.
Right.
And I'll get into that more next time we go through the asset protection trust. Maybe it's time to revisit that.
So what kind of account was it that we did, say, with my father-in-law? We had a small amount of funds.
His was a QIT, because the stuff he had created an annuity that paid.
Annuity. That's what I was trying.
And
I could not come up
And
with the
you,
annuity.
we took some funds and we turned it from accountable. Here's a perfect example.
That's what I was trying to get to.
He had his funds. Let's just say it was money in the bank. I don't remember, but
Yeah.
if it wasn't, we would have turned it into just money in the bank.
Right. That's
Like if
what
it was a cash surrender value on a life insurance policy or something.
Right.
We have these funds and it puts them over $2,000. You know.
Right.
Let's say it's $50,000. Well, it's too much. So what we did was we changed it from a countable asset to a non-countable stream of income. We bought it a Medicaid compliant annuity.
That's what I was looking for.
Now that paid, okay? Now that
Right.
paid out. Now when that paid out, the overage put him, he was single, right?
Yes.
Yeah, okay. So that made this Medicaid compliant annuity, and that would push his income up
Yeah.
because you're getting the annuity. That's on top of what he gets anyway.
Right.
And now it was always push, because most people are $2,000, $2,500. You don't need much more to push you over. Usually, almost always when we do is annuities, it will push us to the income cap, so we need the QIT. That's where it's most common.
Okay.
All those annuities buy.
Okay. I knew there was. We were talking about the asset protection, and that was the other one, and then there's this one. So there's two different accounts.
Well, we have just a moment or two left. The
Sure.
asset, with the case with your father-in-law, the asset protection trust is usually, you guys came to me when he was already in care.
Yes.
Or real close to it.
About to go. Yes.
Yeah. And the asset protection trust is not always the best choice at that time, because it needs those term of years to really.
Right.
Because if we'd have put that property in an asset protection trust, that qualifies as a divestment. That triggers our 5 years of gifting something
Right.
away.
We didn't have that.
Well, the only time that's a good choice is when somebody comes to me and say, hey, we got this million-dollar farm, Aunt Gertrude's ready to go into nursing home.
Right.
She's the owner, we've got 3 families that live off this thing, we absolutely, positively have to protect the farm. Well, if we stick it in an asset protection trust, as soon as we do that, it's non-countable, they can't get at it. But what they can do is hammer us with a penalty period, which is sometimes easier to live with if the farm,
Right.
we've accomplished goal number 1, we saved the farm.
Yeah.
Because it's been in the family for years and stuff like that. So, but normally it's not the best solution because it needs time. So then we go into what we call crisis planning, which are like these other things we can do now that
Right.
is actually in care. And the Medicaid compliant annuity is a popular one. We have spousal ones if you're married. We have the individual ones or some that go to somebody else. But it's what we're literally doing is taking an accountable asset, which is like a lump of money, and changing it to a non-countable stream of income. And that does not enter into his eligibility. So when they say, okay, father-in-law, I forget his name, Don? No, anyway.
Delma.
Yeah, Delma, that's right. How much do you, what are your, application? We file his application and says, what do you got in the way of countable assets?
Right.
Well, we only have like $1,500 worth.
Yeah.
What happened to this $50,000 you had in the bank? Well, I'm glad you asked. Let me explain. They're your rules, but I'm glad to refresh your mind on them.
Yeah.
We bought a Medicaid compliant annuity and turned it into a stream of income that's not countable.
Yeah.
Well, did you do all the Medicaid compliancy parts it has to be actuarially sound.
Right.
They go to the charts and see how long you're gonna live, and it can't be longer than that.
Yeah.
It has to be equal payments, it has to be irrevocable on a sign. Once you do it, you can't go cash it out.
Right,
And
right.
Other than that, there's a
Right.
few other little ones. But anyway, that's how that works. And so he keeps it all. He didn't spend it all on kids.
Yeah.
We kept every bit of it.
Yep, it worked well.
So
It worked very well.
We're close to the end, so.
We are.
Again, I'll just go over the
Your Franklin.
Franklin one. I had the address on, let me pull it up real quick. That address is, it's a Williamson County Public Library, right?
Yep. 1314 Columbia.
1314 Columbia Avenue, yeah. I had to get my glasses up. Franklin, Tennessee.
That's
So
right.
that's Williamson County Public Library, 1314 Columbia Avenue, Franklin, Tennessee. Now that is going to be on November the 22nd, which is a Saturday. So that's at 10 o'clock. We call it Wheels Trust and Nursing Home. If you want to come up there, it's a nice drive up there. On a Saturday, it's not no
Absolutely.
traffic problem. So, yeah, keep that in mind. It's not too early. Not too early. Now, you said you've been there. The girls tell me it's a pretty good size. but
It is a big
So I
facility.
think we'll have a pretty good room, but I'll find out exact occupancy.
very large
Make sure they
facility.
keep up with the RSVP list. We do it up there because we get people requesting coming to their
Sure.
county and stuff like that, so.
Absolutely, absolutely. Stan Pierchoski, everyone. You've been listening to Bulletproof Estate Planning here every Friday morning from 8 to 9. Good to see you again, my friend.
And good to see you, and see you next week.
See you next week.
Israel's Prime Minister speaks out at the UN. I'm Dave Anthony, Fox News.